Afternoon, everyone. This is our last and final presentation for Ethics Week. This is our legal ethics session, real ethics in the virtual world. So we have with us today DC Bar Legal Counsel. We have Hope Todd, Assistant Director of Legal Ethics, Erica Stillabauer, Senior Legal Ethics Counsel, Vega's own Rashi Raj, General Counsel, and Asia Stewart Mitchell, Attorney Advisor. They're going to be presenting your legal ethics training on today. One housekeeping rule: if you have a question, go ahead and type it within the chat or the Q&A. This is a hypo-based presentation, so we're going to leave time after each hypo to give you guys adequate time to answer. If you do want to just verbally say your question, you can raise your hand, and hopefully I'll be able to see it. We have a good number of people on the presentation. If you raise your hand, then I will recognize you. And lastly, 15 minutes prior to the end of the presentation, I will give you guys a random code. You will need to write that code down. That code is going to be used in order to give you CLE credit. So you have to take a post survey, and you're going to need that random code in order to take it. So just make sure you write it down, but I will come back 15 minutes before the end of the presentation to tell you what that code is. We will not be able to provide you with the code after the presentation, so please be sure that you keep it in a safe place. And with that being said, I'll just hand it over to Erica, and you guys can go ahead and get started.
Good afternoon, everybody. It's always fun to be bringing up the caboose on a long series of presentations. So we will try to make this fun and enjoyable, and I would encourage all the participants to participate if you're inclined to answer our hypotheticals or ask questions. It's always helpful for the presenters to know if we're targeting our information correctly. Hope and I imagine many of the people on this presentation today would have very familiar faces if only we could see you. We present to this audience of DC government attorneys quite a bit, and it's always fun for us. This is the first time we've had the benefit of having Vega attorneys participating in the presentation with us. So I would encourage all of you to take advantage of the fact that we have Rashi and Asia here ready and willing to answer questions, because Hope and I have experience in the legal ethics world, but we do not have the same experience in government ethics. And knowing how to spot the difference between those types of issues and knowing what to do when there's an overlap is fun and interesting. So you'll get the benefit of a kind of a full circle of experience here. Ashley, do you want to move us ahead to the next slide? Great. So, we always like to start by telling you about the resources that the DC Bar offers for its members. On our website, you will find the DC Rules of Professional Conduct, many of which we are going to be talking about today. Of course, our Legal Ethics Committee opinions that can sometimes help people put the rules into perspective. We have a number of articles linked on our website, the Ask the Ethics Expert, Speaking of Ethics columns, if you're looking for something, a little bit of a deeper dive on a particular topic. And then I think almost the most interesting resource is our confidential ethics helpline that is staffed by Hope and me and Saul Singer and our newest ethics counsel, Nakia Matthews. So we provide confidential, informal guidance sort of on the spot. You can just pick up the phone and give us a call, and we are always happy to walk you through ethics questions. I would highly encourage you to give us a call, even if you have agency ethics counsel to speak with, or you have plans to talk to a colleague. Sometimes we can just help you get oriented on certain issues. It's not unusual for people to come with us with a conundrum, and they're wondering if on top of their sort of practical issue, do they have a personal interest conflict that's layered on top of it? So we can help people get straightened out on that sort of thing, and then prepare you to participate maybe more fully in discussions with your supervisor or agency ethics counsel. a few quick reminders about these rules. And again, this is why we have Asia and Rashi on the phone with us today. The GC rules of professional conduct, they govern all lawyers admitted to practice in the District of Columbia. May, should, or shall. These are important things to be thinking about when you're looking at the rules. Certain rules create a mandatory duty, other rules create a mandatory prohibition. Some are sort of aspirational goals, which might outline best practices but don't necessarily create a disciplinary standard for attorneys. And parsing through all that and figuring out where you fall on that spectrum is an important part of ethical practice. And of course, last but not least on this page, the rules of professional conduct are rules of reason. They should be interpreted with reference to the purposes of the legal representation and of the law itself. Sometimes that's almost the best answer we can come up with in a particular ethical conundrum when it's really hard to know what move to make. One more, Ashley. Additionally, and especially for government attorneys, it's important to remember that these rules do not exist in a vacuum. We all, at all times, have an obligation to obey other applicable substantive law. For government attorneys, I think this is a particularly important thing to remember because you do have so many other interests at play as opposed to those of a single sort of ascertainable client that you always know whose duties or to whom your duties run. So there are other laws to keep in mind, court rules, federal and state law. Sometimes your ethical conduct is actually going to be dependent on your ability to understand what the law requires you to do. And of course, there are occasions when the rules are permissive and the law is prohibitive or vice versa. And so what you always have to do is make sure that you're conforming your conduct to the most restrictive law, even if that means you're not taking advantage of something that otherwise you would have been permitted to do either under our ethics rules or the substantive law. And I think some of our hypotheticals will tease out some of those issues. All right. So before we jump into the hypos, I just want to remind everyone that this is the favorite teaching tool for Hope and me and for most ethics attorneys, because they really help us understand how the ethical rules actually intersect with lawyers' practice in real life. They're meant to get us into the rules. The answers, sometimes there's a little bit of flex in the answers, and one set of facts or new facts can push an answer one way or the other. So I encourage you to put forth your counterfacts or push on things if you think we're not coming to the right answer, or ask your own twist on the hypothetical. I would like to pretend that these hypotheticals are entirely of my own imaginative processes, but the news has been providing us with so much fun stuff to dive into, so you'll probably see a little bit of hypotheticals that look like they've been ripped from the headlines. I had to restrain myself, and I hope I did a good enough job on that. And of course, to the extent that I got in these hypotheticals a specific agency, or you start thinking, yeah, I know that guy, I recognize that guy, I work with him. I promise you, you're wrong on that. I did not base any of these on real life DC government attorney issues at all. So don't feel like you're seeing your own issues play out here, or those of a colleague. Hope and I are good about that. And that said, why don't we just dive right in? And one thing I'll point out, I would encourage you in the chat, feel free to type in whatever answers you think. You can type in A or B or C or D. It's fun for us to see where things are trending with this audience. So that will help us. But question number one, Charles Loomer is a lawyer in the General Counsel's Office for the Office of the Chief Financial Officer of the District of Columbia. I think I found the longest agency name there was for this one. Due to COVID, he is working from his home office, which is really a corner in his basement. During a burglary, his laptop, which contains sensitive documents containing the city's financial projections and assumptions, is stolen. Has Charles committed an ethics violation here? And 4 possible answers. A, yes, he violated his duty of confidentiality. B, yes, he violated his duty of competence. C, no, there's no ethical violation here. Or D, A and B, is he on the hook for 2 rule violations? We got a C, a couple of C's coming up here. I'm going to give it about 5 more seconds.
One thing I forgot to mention is to make sure you type your answer to all panelists and not just the host.
Oh, lots more C's. All right, I think we have a groundswell here. So why don't we go to the next slide? You all are correct, or you're very casual with your government property. No judgment. You know, we're all lugging our laptops all over the place with kids in the house and all the disasters that ensue. But you're right. I mean, this would just be wildly irrational to tell lawyers they can't be the victim of a crime while they are acting as lawyers. There's no sense there. We do remind people that there are always going to be circumstances in which a lawyer could have a heightened duty to protect information, and the obvious example that comes to mind for me is, you know, in one of these high-profile, you know, Mueller investigations. I presume the attorneys that were working on that investigation had laptops that were in highly secure locations at all times when they were not in the process of being used, right? But there are situations when lawyers incur additional obligations to safeguard information. But in the normal course, having a laptop in a home office in a home does not subject a lawyer to any sort of ethical jeopardy just because a burglary occurs. There is a follow-up here that I wanted to get Rashi or Asia to address, and that is, are there government ethics rules that can be violated, or even are there any applicable government ethics rules for this type of?
Yes, there are some rules that could apply to this, and under DPM 1808, it addresses government property, and the employee does have a duty to protect and conserve government property and shall not use such property or allow its use for other than authorized purposes. Now, so for someone breaking into your house and taking your laptop out of your basement, I don't know that I think that violates government ethics rules. Asia, do you have a different opinion on that? You know,
no, totally agree. Maybe again, if the fact pattern was tweaked a bit, and you know, maybe Charles left it on the seat of his car, visible from his window, or something like that, then we might, you know, want to start getting into 1808. But other than that, no.
Mm-hmm. Also, yeah, I'm sitting in the corner of my basement right now, so I don't want that to be the case.
All right, so the good news is we're all in alignment on that one. So let's take it a step further with question number 2. And in this one, the CFO, Kathy, finds out about the stolen laptop. And she sets up a Zoom call with Charles in which she proceeds to rage about his irresponsibility and the risk to the agency as a result of the theft. Charles knew his daughter was in the basement, but he thought she was engaged in distance learning with her headphones on. In fact, she was recording the call and put it on TikTok with the catchy title, "Watch Karen Zoom." Does Charles face any ethical risk in this situation? 4 possible answers again. A, yes. B, no. Every one of us is at all times vulnerable to a 14-year-old with a phone and social media. C, no. What is described here is simply not confidential information protected by Rule 1.6. Or D, distance learning. You can fill in the blanks there. Many of us are experiencing that right now. So I'm seeing some C's. I saw an A, I think, to start off, some more C's. Thank you, everyone. This makes me feel great because my red herring distraction actually worked here. I think the best answer here is A, yes, and it's because of the really remarkable breadth of our Rule 1.6b that defines client confidences and secrets. Confidence refers to information protected by the attorney-client privilege under applicable law. And secret refers to other information gained in the professional relationship that the client has requested be held inviolate, or the disclosure of which would be embarrassing or be likely to be detrimental to the client. And this is a really interesting definition because it's almost hard to see what doesn't fit into it when it comes right down to it. And I can tell you, as ethics counsel staffing the DC Bar Ethics Helpline, we are always, it's always a fact-specific determination, but a lot of information can get packed into this 1.6b and then create on you a duty to protect it on behalf of your clients. So it's true that it's true that Kathy wasn't spilling secrets about, well, our strategy with the mayor's office is this, or, we're having problems with this internal consultant and we might have violated this rule or that rule, which would be more obvious, perhaps to some of you, that would be confidential information that couldn't be disclosed. But the mere fact that she's ranting and raving and lambasting her employee, that, I think we could squeeze that into 1.6b as information that should be kept secret and should have been protected by the lawyer. His calls with the head of the agency that he represents should not be put on TikTok in any circumstances. Why don't we click through again, Ashley, onto the next slide. I think the closest thing that we have in Rule 1.6 that sort of describes this duty that Charles has as a result of the fact that he's receiving information that I think would fit into 1.6b as a confidential secret is this comment 40. When transmitting a communication that includes information relating to the representation of a client, the lawyer must take reasonable precautions to prevent the information from coming into the hands of unintended recipients. It goes on, but I really think that first sentence covers it all. Now, we can all debate, we're living in small houses. There are times when I'll be sitting in my, one room in my house and I realize I can hear through the floorboards my husband's conversation with someone else. And I think, oh, I better move. This is a little too noisy. It's not meant as a gotcha. And realistically, the odds that this results in disciplinary action, I think, against Charles seem pretty slim, and in large part because it's hard to imagine what advantage the agency gets by going after Charles, reporting him to ODC, and cooperating in an ethics investigation here. Best for everyone is probably to let that video fall to the back of the TikTok queue, assuming that happens. I don't know exactly how TikTok works. So that might have been what some of you were thinking about as well when you're looking at see what are the odds that it's in anyone's interest to go after this. This was obviously a mistake, and certainly that is those are mitigating facts that will probably help Charles sleep a little easier. So we've been talking about Rule 1.6 and the duty of confidentiality here. There is another rule that I think is somewhat related here, and do you want to flip forward again, Ashley? Thanks. And that's competence. Competence and confidentiality are intertwined in a lot of ways. Again, I think this is a little bit less on point, but these are rules or comments that we often talk about when we're talking about a lawyer's duty to protect confidential information. So comment 5, competent handling of a particular matter includes inquiry into and analysis of the factual and legal elements of the problem, and this is the important part, use of methods and procedures meeting the standards of competent practitioners. And of course, comment 6, we have to maintain the requisite knowledge and skill. A lawyer should keep abreast of changes in the law and its practice and engage in such continuing study and education as may be necessary to maintain competence, which is exactly what you all are doing right here. So I think that wraps this up. I did want to mention, we are starting to see on the ethics helpline, we've had a couple of questions surrounding the appropriate use of virtual meetings, and especially what happens when you're in a deposition setting or negotiating with an opposing party, and suddenly they take a break and the other side leaves the microphone on. And so you can hear what a lawyer is saying to the opposing party. There's not an ethics rule that neatly fits into. We have Rule 4.4b that tells you what to do if you receive information from a lawyer that's inadvertently sent. And that usually happens in the context of email or discovery. where you get a tranche of documents or see something, you think they got the wrong person here. I think the rule that we would say applies, is probably 8.4C, which is the general duty of, not to engage in conduct that is dishonest or misleading. So I would tell any lawyer who says, well, what do I do? Do I have a duty to tell the other lawyer, hey, turn off your mic? Conversely, do I have a duty to listen intently and use whatever I learned to the advantage of my client? We would say it's definitely the former. Tell them you can hear them, move away from the audio, don't listen in on the private discussions of another attorney and a client. So that covers the audio questions. I think we've all heard some horror stories about Zoom cameras this week. So if you're not aware of that, you've been living under a rock and you should ask a friend. Okay. So I think at this point, Hope is going to jump in and talk about question 3.
Okay. Thanks, Erica. All right. Hi, everyone. And I echo Erica's sentiments and thanking you all for hanging in for the last session of your training this week. So question 3, the next day, Kathy called Charles to apologize about losing her temper. She told Charles that she had been diagnosed with COVID 4 days ago and hadn't been feeling well. However, she said she was back to normal and planning to head into the office the next day. What should Charles do? A, tell Kathy that if she insists on going in, he will send a blast email to all agency employees informing them not to go to the office until further notice. B, tell Kathy that her actions are not consistent with DC policy on COVID and that he will be forced to elevate this issue up to the office of the mayor if she does not comply. C, because this is a health crisis that could reverberate beyond just the agency, use the bodily harm exception to go so far as to notify the police. D, nothing. Kathy is the agency's duly authorized constituent, and as general counsel, he has an obligation to protect her confidentiality under Rule 1.6. Okay, it looks like the answers are coming in. Number of B's, there's a D. Number of B's. Okay, it looks like most people are saying B, tell Kathy that her actions are not consistent with DC policy on COVID, and he'll be forced to elevate this issue up to the mayor's office, and that is the best answer. So good for you all for getting that answer. And it really arises, the ethical obligation really arises under Rule 113. So let's break down that rule for a little while. So the general rule is that a lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents. So here we have Kathy as the duly authorized constituent, but of course the lawyer's representing the interests of the organization. And so B is really what's known as the report up obligation of lawyers. And this is really, nobody wants to find themselves in a 113B situation. It usually means that there's something going on, there's some actions going on in the agency that is likely a violation of a legal obligation or a violation of law, which reasonably might be imputed to the organization. And here, this is something more than just Kathy decided that, even though she was sick, she's going to go into the office. We're dealing with a pandemic. There are legal orders and protocols in place protecting public health. And these are liabilities for the agency. And so what the lawyer is called to do in these circumstances is to assess whether it's reasonably necessary in the best interest of the organization to report up. And if so, then the lawyer must refer the matter to a higher authority in the organization, including, if warranted by the circumstances, the highest authority that can act on behalf of the organization as determined by applicable law. So that, of course, is going to be a fact-intensive inquiry and is going to depend on what the reporting up chain looks like within the organization. Ashley, please, next. Okay, the rule goes on to remind lawyers in C that when dealing with an organization's directors, officers, employees, members, or other constituents, a lawyer shall explain the identity of the client when it's apparent that the organization's interests may be adverse to those of the constituents with whom the lawyer is dealing. And so this might be a conversation that the lawyer here might have to have with Kathy. D, a lawyer may represent the constituents along with the organization, but that's subject to the provisions of Rule 1.7, which is the general conflict of interest rules, and it's subject to the consent of all of the affected clients. And in terms of the government, that usually is set forth, that would be set forth in some sort of substantive law if the lawyer within an agency had obligations to a constituent as well as the agency. I think in most instances that doesn't happen within the government, but there may be certain situations where a government lawyer is actually representing an individual. Okay, next slide, please. All right, so let's talk about what about this, the bodily harm, the substantial bodily harm and death scenario. So nobody went for that question, but there are certainly circumstances where lawyers are able to make disclosures that they otherwise wouldn't be allowed to make because of risk of death. And so this is the general rule which protects everything, and Erica really talked about the breadth and scope of the definition of a confidence in secret under Rule 1.6. And here's really the mandate that says that you can't knowingly reveal or use the confidences or secret of the lawyer's client in different circumstances, whether it's to the disadvantage of the client or the benefit of the lawyer or a third person. Ashley, next, please. Well, here it is. Here's the death or substantial bodily harm exception. A lawyer may reveal confidences and secrets to the extent reasonably necessary to prevent a criminal act that the lawyer reasonably believes is likely to result in death or substantial bodily harm, absent disclosure of the client's secrets or confidences by the lawyer. And this hypothetical really wasn't, the risk of death or harm seems low here. That's a comment from one of the attendees, and that's exactly right. I mean, and even if one were to argue that it's not low, I think we look at whether it's reasonably necessary at this point when all that Charles knows is that Kathy plans to go into work the next day. And there's some time to deal with the situation. And maybe the risk is especially low if the agency shuts down everybody else's office because they know that there's a risk of that happening. And that can be done, frankly, without going to the police, which is how this particular hypothetical is set up. So even when a lawyer has the ability to make a disclosure under Rule 1.6c, you're still limited by to the extent reasonably necessary, and it's an exception to the rule, so you're always going to narrowly construe the exceptions. Okay, next slide, please. Were there any other questions on that particular hypothetical before we go on to question 4?
Oh, I saw in the chat that there was one that said that the risk of death is usually low here.
Yeah.
You know, and I guess that just goes back to these are rules of reason, and you know, I agree that that's a little bit of a stretch. 5 or 6 months ago, it might have looked a little bit different, but I interpret this rule. We generally tell people you don't have to wait until a catastrophe occurs before making a call under that, you know, reasonably believed standard.
Right. And the other thing is there are comments to Rule 1.6 that sort of guide a lawyer in terms of whether or not in a particular instance there is a reasonable belief. So oftentimes we're dealing with a situation where your client is an individual person who may be threatening to do something that would, harm someone else, whether it's to, set off an explosive or to, harm someone with a weapon. And then in those scenarios, the lawyer's looking at of the indicia of whether or not does your client have a history of being violent, is there a past crime, is there a psychiatric diagnosis, things like that would feed into the lawyer's reasonable belief of the likelihood of substantial bodily harm or death. So it's always going to be a fact-intensive inquiry. And, the two things, whether it's reasonably likely to happen, but also in terms of who you make the disclosure with and how much you disclose, only that which is reasonably necessary to prevent the harm. But here that wasn't the best choice because there are other options. Okay, question 4. Kathy's not swayed by Charles' advice. Charles, realizing he doesn't have much time to act, loops in his brand new assistant, Jared, who came highly recommended from the DC Department of Health. Charles asked for Jared's help in researching the DC government's COVID-19 policy so that Charles can figure out whom to notify in the event the agency needs help with enforcement of the policy. Within 30 minutes, Jared emails Charles that he's already briefed Dr. Nesbitt, director of DC DOH, on the situation and that she's expecting a call from Charles to discuss next steps. What has gone wrong here? A, nothing. Jared is well connected and knows how to get things done. B, Rule 1.6, confidentiality was violated. C, Charles failed to properly supervise Jared. And D, B and C. So we have a number of B's. We have one D. We have an A. We have more D's, which would be both B and C. So it's kind of spread out, but mostly among B and D. So the question is, did Charles, were there 2 violations for those who chose? So that is the best answer. The best answer here is that both B and C, and let's look at why. So 1.6K is the rule that says that the client of the government lawyer is the agency that employs the lawyer unless expressly provided to the contrary by appropriate law, regulation, or order. Next slide, please. So under Rule 1.6, we just talked about why the confidentiality is broad, and here we have the new assistant picking up the phone, calling outside, and, sort of blabbing all the problems of Kathy, going rogue and wanting to do something that may harm the agency with someone outside the agency. So we do have a 1.6 problem. The question is, do we also have a supervision problem on behalf of Charles? Well, we know that he's got this new non-lawyer assistant. And so what are the obligations that arise when you have assistants? So this, there's one that deals with both supervising lawyers. This one deals with responsibilities of lawyers regarding their non-lawyer assistants. And it essentially says that with respect to a non-lawyer employed or retained by or associated with a lawyer, a partner or lawyer who individually or together with other lawyers possess comparable managerial authority in a government agency shall make reasonable efforts to ensure that the firm or agency has in effect measures giving reasonable assurances that the person's conduct is comparable with the professional obligations of the lawyer. So what that basically means is that the agency itself needs to have in place adequate training for all of the non-lawyer assistants with respect to what the legal obligation, what the ethics obligations of the lawyers are. So that's A. But what about the direct supervisors? That's what we find in B, that the lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. And here it seems that Charles has not done a good job with supervising Jared and making sure that Jared isn't going off and sort of telling everybody the business of the agency that otherwise would be confidential information. I have a question here that says, would it still be a violation if Kathy's name wasn't disclosed? And my sense is yes. I mean, I think the situation that you have, the question there, that's an interesting question, because could you get advice about actions within the agency. I mean, would you also be not disclosing the agency? Because it seems like I'm trying to, my test is sort of thinking about what's in the Washington Post on the front page, and or what's on the, what are you seeing in the 3 minutes headlining the news? DC agency, official refuses to abide by COVID regs as reported by the Department of Health. I mean, we don't want that sort of situation, and the ability of lawyers to go outside of their agency to seek assistance, I think that's really what Charles was asking Jared to research, and instead of researching that, he went off and sort of spilled the secrets of the agency. Okay, let's see. I see another question here. The hypo-specific was asked only to perform research. Supervisors ultimately responsible for the disclosure, but what could the supervisor have done other than provide instruction on the task? Well, I would agree with that. I mean, to the extent that there are employees that do things that aren't ratified without the knowledge of the specific conduct, I think here the hypothetical was meant to make the assumption that we had a new employee who was just given very cursory instructions, and on those instructions really went out and spilled secrets, where that really should be one of the very first things that non-lawyers working within a lawyer's office, whether it's within government or outside of government, are trained on. It may be the most important thing that you train a non-lawyer who works with a lawyer on, because it is a fundamental obligation of the lawyer-client relationship. So, while I agree there's certainly going to be situations where supervisors not going to be held, I think reasonable efforts to ensure that the person's conduct is comparable with the lawyer's obligations is going to look to see, did you train them on confidentiality? And I see another question, does the bar offer any training on 5.3 that non-lawyers can take to help them better understand? I mean, that's a great question. We really don't, not that I'm aware of, aside from we have a specific CLE targeted at supervisors who have non-lawyer assistants, but there really isn't anything that I'm aware of to do that. But that's a good suggestion. So I'll take that under consideration. Okay, any other questions on question 4? Next slide, please. Okay, so here's a follow-up here for Rashi and Asia. What if Jared instead connects Charles with the CEO of a Rockville-based pharmaceutical company that offers the agency a free dose of curative elixir for the CFO? What does Charles need to think about when assessing whether or not it would be appropriate to accept the offer? To whom Charles can go to for further advice and guidance? And what if the pharmaceutical company CEO is Jared's brother? So there's a whole bunch of questions embedded in there.
Yeah.
So,
I guess sorry, go ahead, Asia.
Sorry, Rashi, go ahead.
To start, one of the first things we were thinking to consider is this Rockville-based pharmaceutical company a prohibited source? Is there any sort of relationship that this company has with DC government? And I guess beyond that, then we're getting into gift rules.
Yeah, I agree with that. That's what comes to mind when I read the follow-up fact pattern. The company would most likely be a prohibited source. The facts kind of lend themselves to that because the company, is offering something. So they, it would lead that they want something from the agency, so they'd be a prohibited source for purposes of this particular fact pattern. And then that would activate the gifts rules, and there's a lot of restrictions around what district government employees can accept from prohibited sources. And then another layer is added by the CEO potentially being Jared's brother, even though I don't think nepotism will be implicated, because nepotism for purposes of our rules is generally between two district government employees. But we do have a rule that kind of parallels our nepotism rule that talks about the requirement to perform your duties in a manner that lacks, that is impartial and lacks bias. And so with this fact pattern, you can definitely infer that there's some sort of bias because the CEO is Jared's brother. So those would be the roles that come to my mind in this fact pattern.
The other thing I was thinking is if Jared, what if Jared instructed his brother to give Charles a free vaccine for the spirit of the elixir? Then is that a gift between employees? What's the value of the gift? And I think maybe we didn't address the one, to whom can Charles go to further advice or guidance? Ethics counselor within the agency. And, if it turns out that Charles is the ethics counselor or can't reach that person, then of course can come to Vega.
Okay, great. Thank you. I do
a few
see
questions.
a message. Oh, sorry. Go ahead.
No, I'm sorry. I just didn't know if you saw that. We had a few more questions in the chat. I'm sorry.
I can see the chat. I'm not looking at the question and answer. So in the chat, I see, could the supervisor, but the supervisor could defend by showing at some point there was reasonable training. It need not occur each time a task is assigned. Correct. And the answer to that is correct. I mean, we're looking at, I think that's why the word reasonable is thrown in there. We want reasonable assurances. We want reasonable procedures and protocols. So you're going to do a training now, would it be reasonable to hire someone and do an onboarding training and then they never hear the word confidentiality again? I don't think so. I mean, I think this is something that probably needs regular training, periodic, does it have to be done once a month? No, but should it be done once every 2 years? Probably. I mean, again, we're looking at what's reasonable in the context of, what would normally arise in that employee's daily task. What should they be aware of on a regular basis? And then the only other comment I see here is just a request that Asia increase her volume because it's a little bit hard to hear. Are there any other questions there? That's what I see in the chat.
There's one more. Why is Garrett sharing the CEO's health information with pharma?
Yes. So I think that is a question. I think that is a great question that, in addition to the legal ethics 1.6 confidentiality issues that arise, there's also the substantive law. And so there are likely laws around employees' health issues that would be protected under the substantive law. I think the challenge for Charles is something that I mentioned in the beginning in this hypothetical, and that is that we're in a situation where an employee going to work like this may actually create liability for the agency under the pandemic protocols that the agency is subject to, or the citizens of the District of Columbia are subject to. So we're sort of, it's the hypothetical we created to get us to talk about these issues. But I do think there is another issue here, and that would involve the private health information. Okay, next slide, please.
Hope I have the actual CLE code now.
Okay.
Is it okay if I can announce it right now?
Mm-hmm.
Okay, so folks, again, you will need this code in order to take the post survey to get your CLE credit. So I'm going to announce it 2 times. It's E, please write it down. It's E as in Edward, L as in Larry, the number 2, and then the number 3. E as in Edward, L as in Larry, 2, 3. EL 2, 3. So you'll receive an email to take a post assessment, an email from the DC Bar, and you will need that code in order to take the post assessment in order to get your CLE credit. Again, it is E as in Edward, L as in Larry, 2, 3. Thank you.
Okay, so moving along to question 5. Kathy is on a roll. She arbitrarily decides she wants to fire the city's long-term accounting firm and give the job to her neighbor's son, a newly minted accountant. She calls it a fresh start. She orders Charles to get started on whatever action is necessary to terminate the accountant's contract. Which of the following are Charles's options? A, determine the lines of reporting authority in the District of Columbia so he can report up the chain. B, follow Kathy's direction. She is the duly authorized constituent of the organization, and as such, she sets the objectives of the representation. C, consider whether as an employee of the city government, he has a duty to report concerns, even though he would be revealing confidential information. Or D, ignore Kathy and hope she settles down soon. I see a couple A's. C, A or C, C. I have a mix of A and C. That's what's coming in. Okay, next slide, please. And those are correct. The best answer would be A or C. And we've already talked about, why, because we're in this reporting up where there could be a violation of a legal obligation or law, which might be imputed to the organization, is likely to result in substantial injury to the organization. And these are, of course, always going to be fact-intensive and fact-specific analyses that the lawyer is going to have to undertake. But if there is going to be substantial injury that could be imputed to the organization, then the lawyer needs to figure out whether or not and who the lawyer needs to take this up the chain to discuss it. Next slide, please. Okay, here's the other one. So the answer under C dealt with whether or not a lawyer could reveal confidential information as a district employee, and it's always important to remember that there is a special exception under Rule 1.6E 2A that says that a lawyer may use or reveal client confidences or secrets when, if a government lawyer when permitted or authorized by law. So again, we're always going to look at exceptions narrowly. We're going to narrowly construe them. And here we're talking about whether it's to the extent reasonably necessary, but that's a situation where you may want to also reach out to your agency ethics counsel or to Rashi or Asia at Vega. Next slide, please. Okay, so question for Vega, does Kathy's proposal violate DC's preferential treatment rules?
Can everybody hear me okay? I know there was a comment about my volume. A little bit. I'll try to speak up as best I can. So I would say yes, this one does implicate the preferential treatment rules. Whenever you're dealing with family members with regard to contractual relationships, there's a strong inference that our preferential treatment rule is being violated. Of course, we would go a little bit further and gather some other facts surrounding the process of awarding the contract. Did they consider anybody else? From this fact pattern, doesn't seem like they did. Seems like there was a direct instruction to hire I think it was the brother, the accountant. And so, I mean, based on just what we have here in the four corners of the fact pattern, I would say that there's a strong inference that the preferential treatment rule is being implicated and being violated.
I agree. Plus, just reading it, that doesn't look good. If that's your agency, you don't want to see that. And
you saying it not look good, that brings up our appearance rule. We have a rule that essentially says if you're doing something and it might not be a technical violation of our rules, but it appears to be unethical, that the appearance itself could be a violation as well.
Just unmuting myself. So to follow up on what Asia was just mentioning, we have this concept that is more or less been stripped from the rules of professional conduct, the concept of the appearance of impropriety. And we still often get callers who ask us, well, doesn't this have the appearance of impropriety? And the truth is, appearances are too much of they're subjective. It's too subjective a standard for us to tell anyone you can't do something or you must do something, because people get outraged about all sorts of things, which are not, ultimately harms that the DC bar is seeking to prevent. But I would tell anyone who's saying there's an appearance of of impropriety, that should trigger you to look really closely at the ethics rules and make sure you're not doing something else wrong, right? It's not good when things look bad. And so don't ignore those instincts. Even, at least under our ethics rules, you're probably not going to ever get charged, at least under a rule that says you violated, you engaged in misconduct because whatever you did had the appearance of impropriety. It's a good signal that something needs to be looked at more closely. So moving on here to question 6. When it rains, it pours. Charles ventures into the office and receives notice that the agency has been served with its first COVID-related employment lawsuit from Claude, a longtime employee. Kathy is outraged when she finds out that the OAG attorney representing the agency in the matter won't allow her to dictate the terms on which the agency will settle. Charles tells Kathy, she is right, the client always has the right to set the objectives of the representation and approve settlement terms. Go pound sand. A government attorney's authority and control over decisions concerning the representation may be expanded by statute or regulation beyond the typical limits. C, lawyer and client, in this case the agency, need to work together on the strategy. Or D, as agency general counsel, Charles is responsible for making decisions in litigation matters, and he approves of the OAG attorney's plans. All right, we've got A's, we've got C's. I'll give it another minute. Some more A's. All right, I'm going to put you out of your misery. You're all polite. You're all too polite right here. This is where you get the opportunity to tell her to go pound sand. I wouldn't actually recommend using those words, but I think the way I would see this is that a government attorney's authority and control over decisions concerning the representation may be expanded by statute or regulation beyond the typical limits. And that is Rule 1.2D, which I just read. Now, again, that answer is presuming that in this case, the Office of the Attorney General or the attorney from the Office of the Attorney General who's representing the agency, there is a statute granting them the authority. But I think the idea is that in the government setting, you might have a body of expert litigators who are going to have the authority to tell a client, your settlement demands are not reasonable here, or it's consistent with the government's interest or your agency's interest to settle this case rather than trying to go through a litigation process to vindicate you. So that's how we would view this, and I would assume that in this case, the Office of the Attorney General is really going to have the authority to tell the agency, when it's time to settle, on what terms it should settle, that sort of thing. I can't pretend to know enough about how OAG works with its client agencies and how much collaboration there is along the way. I assume that people try to be congenial and get along and develop a common strategy. That would obviously be the goal. But I think there are limits to the authority that the so-called client agency has in this circumstance. And again, that is, for those of you who went with A, you're right, because we often trumpet the normal rule, the standard rule, which is found in 1.2A, which is that a lawyer shall abide by a client's decisions concerning the objectives of the representation and shall consult with the client as the means to which they are to be pursued. And it gives specific authority to the client to make certain decisions about the course of the representation. But again, there is a limit in provision D, and I think that's probably applicable here. Go on to the next slide. All right. We're rounding the corner here on your weekend. So Claude, who is represented by counsel in his litigation against the agency, emails Charles that he needs to come into the office for a few hours the following week and asks for Charles' assurance that a COVID safety policy is in effect for the agency. Charles is relieved that he has an excuse for not responding to the email from Claude because A, Claude is represented by counsel in an action against the agency, which is Claude's client, or sorry, Charles's client. B, the matter that Claude is inquiring about is directly related to Claude's lawsuit against the agency. C, A, and B, or D, is it none of the above? And remember, these are his excuses for not responding. I see some C's and some D's rolling in here. Give it another second or two. All right, Ashley, do you want to, oh no, see, I like a correction there, okay. We're actually going to go with D here, the none of the above, and here's why. You know, 4.2a is the no contact rule, and this is I think this is an important rule for lawyers to keep in mind because it's easy for another lawyer to call you out for violating it, right? What it says is during the course of representing a client, a lawyer shall not communicate or cause another to communicate about the subject of the representation with a person known to be represented by another lawyer in the matter. So far, it sounds like we're talking about Claude and Charles here, right? Unless the lawyer has the prior consent of the lawyer representing such other person, or is authorized by law or a court order to do so. Now, again, I will admit that I'm drawing some conclusions here, but the fact is Claude is an active employee of this agency that Charles represents. And it is hard for me to believe that there is not some statutory authority out there that will allow that agency, through counsel if necessary, to communicate with an employee as necessary about something that is related to that person's employment, even if there is currently a lawsuit going on. You know, there's sort of no great options here. You know, for all we know, Claude has also sued HR and the head of HR in a personal capacity in connection with this lawsuit. And in those circumstances, it wouldn't be very satisfying to tell, you know, an officer of an agency, yeah, just go chat with this person yourself and figure out what he wants and what he needs from you. That's not a good solution. So my guess is that Claude is actually going to have to respond in some way here, and then he'll find an authorized by law provision that will allow that to happen. Anyone want to come up with a different scenario there, or an alternative real life situation? All right. Well, there are 2 minutes left here. I am happy to field any last minute questions. Hope and I are always happy to field calls on the ethics helpline, and we, you know, encourage you to call if anything comes up.
Erica?
Yes.
Actually, on the last scenario, as a little bit of a scaredy cat, didn't you just CC his counsel?
I think that's a great idea. I think that's a very good middle of the road solution. I'll tell you, the reason I don't raise that, I guess I didn't raise that, is people tend to get overconfident with CCs, and I actually wrote an article in the Washington Lawyer on this very topic recently about the hazards of reply all. The fact that you are copying a person's attorney doesn't mean you're complying with 4.2a. You know, you really need the prior authorization before sending such an email to comply with the letter of 4.2. And to make matters even worse, this is sort of an infuriating way to end the day. What we will see sometimes is lawyers writing a really hostile email to opposing counsel and copying their own client. They're showing off, posturing for their client. The opposing counsel will respond back and reply to all and say, oh, and all of a sudden the guy who initiated it, the aggressive lawyer, will say, you don't have my permission to copy my client on these communications, even though I'm the one who initiated it by putting him on the CC line. So people get very sensitive and prickly here, and it's a little bit of a minefield for lawyers. But in these circumstances, I would agree. Again, assuming we've got some basis in law for him making that communication, I think it would be wise to copy Claude's counsel. It's a little bit of a belt and suspenders approach there. All right. Thank you all for bearing with us. Do you need to close anything out here, Ashley?
No, just going to leave that
All
up
right.
there.
Thank you. Thank you, Rashi, and for joining us. Thanks,
Thank you.
Dr. Schiff here.
Yeah, thank you guys. To our panelists, our friends at DC Bar, thank you. We have called on you all for the last 3 or 4 years to present for our ethics program, and you've always answered that call, so thank you all. To our attendees, thank you all for attending Ethics Week. We hope that you have enjoyed this week as much as we have enjoyed providing you with information. It's been a pleasure to serve. You have our contact information if you have any questions. You will receive email. Erica. You will receive an email from DC Bar post-evaluation. You're required to use that code that I provided you with, EL23. Make sure you write it down. You're required to use that code for the evaluation. That's how you receive your CLE credit. The email, the survey will come directly from DC Bar. Okay, thank you all, and have a good weekend.